SJC-11692, Commonwealth versus Felix.
Ms. O'Brien, good morning.
Good morning, Your Honors. May it please the Court, Leslie O'Brien for Mr. Felix. The defense in this case was that the defendant was guilty, but that he was guilty of something less than first-degree murder. So it was extremely important in this case that the jurors be charged on any lesser-included offenses that were supported by the evidence. The defendant's first argument is that he was entitled to have the jurors instructed that the Commonwealth must disprove beyond a reasonable doubt heat of passion based on reasonable provocation. And they should have been instructed that if the Commonwealth failed to meet that high burden, the correct verdict would have been manslaughter in this case. Now, the defendant testified in this case, and I suggest that that's a very important fact in this case, because where the defendant testifies, the analysis of whether he's entitled to this instruction requires the trial judge to credit the defendant's testimony. I'm taking that from Commonwealth versus Parker. I believe it's Justice Nolan's statement, that determination, whether that instruction is required on heat of passion, must be based on the hypothesis that the defendant's testimony is entirely true.
It's in a light most favorable, correct? We have to,
Yes.
The judge should credit what the defendant has to say in a light most favorable, give an instruction when appropriate.
Yeah, certainly in the light most favorable. I'm even suggesting that this is stronger language, that it's not just the light most favorable. His testimony has to be presumed to be credible when the trial judge analyzes.
So you're going to get this, I apologize, but so can you tell us exactly what he said about the confrontation leading up to the strangulation?
Yes, exactly, Your Honor. And this, the heart of the testimony that I'm relying on here is it's in volume 4 at pages 60 and 61. Where the defendant describes what happened on the morning of the homicide. And what he says is that he went to his own home, the home that he shared with his wife, that he went there with peaceful intent. He wanted to reconcile with his wife. That when he entered the bedroom, that was his bedroom that he shared with his wife said, "What are you doing here?" And she lunged at him and was punching him and swinging at him. And he testified that she was punching him, not as has been suggested by the Commonwealth, that she was trying to punch him, but that she was punching him. And he stated that at that point he snapped. Now, and he actually went on and although I think that the word snapped, using the word snapped, is it's clear that what he meant was that he became extremely angry and lost control.
Well, we have to go back to what happened before he snapped.
Yes.
To decide that snapped means what you say it means. I mean, so even if we accept what he said is true, she lunged at him and she was punching him.
Yes.
I mean, that conduct has to rise to a certain level of physicality to be considered reasonable provocation, doesn't it?
Well, it's a matter of, under the definition, it's the ordinary person is the standard. It's such provocation as would produce in an ordinary person a state of passion or anger or fear that would eclipse his or her capacity for restraint. And the instructions, actually all of the model instructions that I looked at, the 1999, which I think the court has referenced as the MCLE instructions.
Well, no, the homicide was SJC. It was we were talking about other crimes, the MCLE, home invasion, things like that. But 1999 is the first set of SJC.
Well, the 1999 set, the 2013 set and the proposed 2016 set all say that, all reiterate that a single blow may amount to reasonable provocation.
Well, that's true, but it depends on what the single blow is. I mean, it's an objective standard, right?
Yes.
And I think the assumption is that whatever it is that the victim does has to pose a threat of serious harm to the defendant.
Your Honor, I'm not certain at all that that's true, even though.
I'm quoting from, I'm looking at this Ling case where that's exactly what we said.
Yes, in Lang, the court does use that language, but in Lang, it appears that that's certainly, I'd suggest it's a factor. It's a factor to be considered. It can't be a requirement because reasonable provocation in extreme circumstances can be based on words. So the danger of physical danger or the danger of physical harm can't be necessary. It's certainly something that should be taken into consideration as a factor, because the fear is one of the states of mind that can be reasonable provocation, but so can anger. And as I've said, what I'm suggesting really is that it becomes a jury question, and the jury will be properly instructed that even a single blow can amount to reasonable provocation.
Is the danger that a judge would conflate the predicates for self-defense with the predicate for this instruction on provocation? That self-defense requires a great deal more physicality before there's a self-defense claim versus sudden combat.
That is part of what I've been arguing here, Your Honor, that there may have been some muddying in the arguments that have been raised here between self-defense and heat of passion based on reasonable provocation.
So let's assume for the moment that you're right, that the instruction should have been given. You say on page 14 that the defendant did not ask for that instruction.
That's very true. The defendant did not ask for the instruction.
So why would it produce a substantial likelihood in view of the totality of the evidence?
Because, Your Honor, as I've stated, when the jurors are instructed that it's the Commonwealth's burden, and the language is as to the effect, I can't quote it exactly, but the effect of it is that even if you find all of the elements of murder, if the Commonwealth has not proven beyond a reasonable doubt, has not disproven beyond a reasonable doubt, heat of passion, then you cannot find the defendant guilty of murder.
But you'd still have to show that there was a reasonable possibility that if that instruction had been given, there would have been a possibility that the jury may have found manslaughter.
Yes,
but
exactly.
Here, I mean, here you've got him locking the door, correct?
Which would be consistent with spouses having a private conversation, Your Honor.
Waiting, allegedly, just beginning the conversation after the son had left.
Well, that was a theory that the Commonwealth raised, certainly.
But there's no dispute that the son was gone.
There's no dispute that the son is gone. I think it's a little bit far-fetched to say that was part of, that the defendant was planning. That was a theory that the Commonwealth proposed.
Now, tell me, with regard to the Judgment Day,
Yes.
was that a text? Was that a calendar note? What was that?
It was I believe it was a text to a friend.
And when was it texted?
It was texted I'm not sure of the exact time frame.
Was it before? It was?
It was before, and the defendant's version of that was that he felt that this was a momentous day for him, that he was either going to get his life back, meaning his family back, or that he would not, and that he felt that this was God's judgment on him if he was returned to his life. So that was his explanation for what he meant by that. And when I say that there may be, that this raises a substantial likelihood of a miscarriage of justice, what I'm saying is that certainly at least some of the jurors might have credited what the defendant had to say, might have felt that he snapped, that he lost control, that this was a completely unexpected attack, that he suddenly found with peaceful intent, he was, to his surprise, attacked and punched.
Let me ask you about that, because she was strangled with a ligature that he had to go get from another room.
Well,
So-
actually, the theory of the Commonwealth, or the primary theory, and when I say this, I'm going on the cross-examination of the defendant and the closing argument of the prosecutor. It seems to be that one possibility was at least this phone charger that was on the bedroom floor. So he really didn't have to go anywhere. If they were correct that could have been the ligature,
Well, I
he
thought
didn't
it
have to
was
go anywhere.
I thought it was found to be a cord from the daughter's bedroom. Is that not the case?
It's not the case. The actual ligature was never identified with any certainty. So, and it was suggested that it could have been this cord that was just there on the bedroom floor.
But that cord didn't have the plug in it, correct?
The testimony was that it wasn't plugged into the wall.
No, I know, but was it,
Did it have the thing that
did it
goes
have
into
the
the
thing that
wall?
goes into the wall? I thought they had been cut.
Yes, there was a white wire that was, I believe, in the daughter's bedroom. That was the wire that was cut. That's my recollection
But
of
that would be
the
a
testimony.
break in this so-called, when your client snapped, when she lunged at him, if he has to leave or has to pause to get a weapon, that would be a break, wouldn't it?
That would be a break of at least a few seconds, but there's really no proof that happened. The Commonwealth never claimed to know which of these items that were found in the house were used.
Well, it's
against-
different from strangling with your hands. I mean, that would be more consistent with somebody who snaps and immediately grabs the person by the neck with hands, but that wasn't what happened here.
Well, the ME certainly
We
said that
know that, right?
a ligature was used, but if the ligature was right there, as I believe was suggested by the trial prosecutor, if the ligature was right there, it could have been picked up in
Tested?
a second.
Was it tested for DNA or anything?
There were indications that it was being I'm not sure if I'm mixing this up with what I've seen in the trial, file, so I'm hesitating. I'm not sure what's on the record there. But I know there was no proof offered at trial regarding what the ligature was. There was certainly no testimony that the defendant brought a weapon with him, which I'd suggest is significant. And the Commonwealth doesn't suggest that there was that he did so, but she does cite to cases where the defendant actually had and confronted the victim with a weapon. There's no proof in this case that was the circumstance.
Well, he didn't live there. He hadn't been there for a month, right? And he had this restraining order against him, so.
There was no restraining order, Your Honor.
There was no restraining,
was
this
no-
is not the case?
There was no,
Is this the one where he was training at the gym 4 days a week?
there was testimony that he was training at the gym.
And that he was a bodybuilder, was he?
I'm sorry, I missed the last word.
Bodybuilder?
A bodybuilder, yes.
Was.
Yes.
Was there any information about the relative sizes of the defendant and his wife?
I don't recall any such testimony, Your Honor, and I'm certainly not suggesting, I don't know what the wife's physical capabilities were, and I'm not even suggesting that there was any kind of proof that she could have beaten him up. But to say that a
No,
37...
it was going to your question or your observation that there was no weapon, and
Yes.
sometimes your own body can be a weapon if you're strong enough
I
and big
see
enough.
what you're saying. I wasn't
Yeah,
sure.
that's-
What do we do with the case law that Judge Tutman relied on when she denied the instruction?
Judge Tutman relied on Rembazewski, which it's interesting. That was a case where the only evidence that was offered in support of this voluntary manslaughter was that the defendant had scratches on his face. There wasn't even any testimony that there was a physical confrontation. There wasn't even any testimony that came from the wife. So the court said that in that case it was an extravagant suggestion that this could support a voluntary manslaughter instruction, and I thoroughly agree. There was nothing there to support a voluntary manslaughter instruction. Same with Commonwealth v. Lenk. There was nothing there that the victim had even approached the defendant in any way. So those cases are clearly distinguishable.
In fairness to Justice Link, it was Lang, right?
Lang, I'm sorry.
I understand the confusion.
Yeah, Lang. But there was, the court emphasized in that case that there was no evidence at all that the victim had approached or
And the
threatened.
difference in this case is your client testified to these facts? From Lang and the other case?
He testified that he was attacked, so that's clearly distinguishes this case from those cases.
So going back to the substantial likelihood of miscarriage.
Yes, Your Honor.
The jury here found him guilty both of deliberate premeditation and of extreme atrocity. Correct?
Only deliberate premeditation.
Only on deliberate premeditation, I'm sorry, okay.
Yes, they were
So-
instructed on extreme atrocity. They rejected extreme
Well,
atrocity.
they didn't find it in any
Well,
of
they didn't find it. Beyond a reasonable doubt.
So if the
exactly.
jury had in any way credited the view that he came there to reconcile and that after she punched him, he lost it, how could the jury have found deliberate premeditation?
Because the instruction on premeditation says that premeditation can be formed in only a matter of a few seconds, even if it was a matter of his reaching to get the phone charger from the floor. The way jurors are instructed now on premeditation, it only takes a few seconds. They could find premeditation based on that. If I could just come back to the cases that have been cited to suggest that there was no risk of harm or substantial harm or threat of harm. I'm still of the view, and I'm asking the court to really consider whether that's necessary as to heat of passion based on reasonable provocation. But I also want to point out that the cases that the Commonwealth has compared this case to are very different. They are cases where the victim was either very elderly or handicapped. There's nothing in this case to indicate that this woman was disabled. There's no reason to believe that a 37-year-old woman could not, by punching an individual, create substantial harm. This is very different from the circumstances in Walden, in Vatcher, where we're talking about an 11-year-old child, in Parker, where we're talking about a handicapped 79-year-old man. So I see that my time is nearly up. I just wanted to just quickly see what I've missed. Actually, I will rest on my brief, and I'd ask the court to grant a new trial.
Great,
Thank you, Your Honors.
Ms. Sullivan, good morning.
Good morning. Good morning, may it please the court. Jane Sullivan for the Commonwealth in this case. The jury in this case convicted the defendant of deliberately premeditated first-degree murder, meaning that the jury had to find on correct instructions that the defendant specifically intended to kill the victim and that he did so after reflection with deliberate premeditation. And the evidence before the jury overwhelmingly supports that verdict. The defendant did request some instructions on an involuntary manslaughter, but in any event, the manslaughter, both theories, voluntary and involuntary, were broached with the trial judge. She actually brought up the voluntary manslaughter herself with input from all counsel, and the judge correctly determined at that time that there was no basis in the evidence for either theory of manslaughter.
Isn't Ms. O'Brien correct, though, that if the defendant's statement raises the issue, as improbable as it may be, isn't that enough to get the voluntary manslaughter?
Yeah, absolutely. And even if it's incredible or whatever, yeah, I would say that, yes, you have to credit even the incredible
So if
statements from-
he says, she lunged at me, she punched me, she did all these things to me, why wouldn't that be enough?
Because number one, the victim was weaponless, but number two, you have to look at what the defendant said. And he did say she came lunging at me, swinging at me, and I believe it was punching at me, because when he spoke to the police officers at first, one of the police officers said, who went after who first? I don't know. Who punched who? We didn't punch each other. We grabbed each other. Did she hurt you? Are there any? Because there were some signs, he had some blood on his lip. What happened with the blood on the lip? Was that from your wife? Oh, no, that's when I tried to hang myself, kill myself after the fact. So you have to look at the defendant's testimony, but you have to look at it in its entirety. And I would also direct the court to...
I'm sorry, let me stop you there.
Yeah.
If the defendant gives inconsistent versions, do we not have to look at it in the light most favorable to the defendant, even taking the best version for him and not the less good version for him?
I would suggest that that is probably accurate, but you cannot distort what the defendant says. And here the defendant explicitly said, no, we did not land punches. We grabbed each other. And what he more importantly says at pages, I think, 108 and 109 on transcript 4, she just came lunging at me. That was the last thing I heard from her. The defendant said he was not mad at her. He was never mad at her. He just didn't like the things she didn't do.
So are we going under the reasonable provocation part of it or the sudden combat part of it?
Well, I believe if you're trying to credit that she came swinging and landed a punch at him, I think we're under the sudden combat part of it. But even if there's some, you can do it under both, you still need a provocation that it would prompt a reasonable person to become so overwhelmed with emotion that he or she could not appropriately reflect on what they were about to do or restrain themselves for doing it.
And we've said on reasonable provocation that it can be mere words, it can be...
Well, it can be mere, well, it's got to be, no, it cannot be mere
No,
words.
I'm sorry.
It needs to be mere words that...
that would raise...
Yeah, raise a tremendous impact. And I'm not aware of any case where there were, maybe one schnapps, but the defendant specifically says there was nothing like that. There's no allegation that he found his wife committing adultery or anything like that.
That was the classic example.
That's the only one that I'm aware of. But the other ones where they say the one blow would be where, like in Acevedo, where a defendant, the defendant is sort of surrounded by the victim and some of his friends. And I think he was either punched or pushed to the ground and beaten. You don't know who did what to whom, but there is an attack, and then the defendant lashed out with a knife. Here we have nothing like this. By the defendant's own statement, we have him sneaking, I would suggest the evidence clearly shows. He was out of the house for a month. He came back to the house in the early morning hours, sometime after 6 a.m. when the older son had left. He waits until his young daughter, who was sleeping in the room with the mom, leaves the room, goes into the bathroom, tells the daughter by his own testimony that the mom was sick, goes into the bedroom, locks the door behind him, finds his wife in front of the bureau after having just come out of the shower dressed only in a towel. She makes it clear to him, which he says, that she does not want him there. And then she starts lunging at him, swinging at me, and then I snapped, I lost it. That was the last I heard from her.
And how do we distinguish this level of physicality such to give rise to this instruction with that of self-defense? What's the difference?
I would suggest that on sudden combat or even reasonable provocation, there wouldn't be necessarily the requirements that you would have for the complete defense of self-defense. Reasonable provocation is, a mitigating offense. It doesn't absolve someone of liability for their crime. It's just to take into account the frailties of human nature.
It could be imperfect self-defense too, though, right?
Well, it could be excessive force in self-defense,
Right.
exactly, right, that's true, and that would amount to the same thing. But here, I would say that you need something more in any case than just when you have one person facing another person, just someone lashing out as though they were going to try and hit you. Even if they land a punch, that should not be legal justification to respond in a homicidal rage by this. Not only was the victim in this case strangled with a ligature that left at least three ligature marks, one 12 inches, one 4 inches, all 1/4 of an eighth inch around her neck, and fractured the cartilage in her neck, and she had petechial hemorrhages throughout her face. Her body was badly bruised. The medical examiner said that her body suffered significant injuries from on her face, from her cheek, underneath her chin, underneath the top of her scalp, the front and backs of both her arms and her legs, in the right side of her tongue, on her back, and particularly on her shoulder blades. And the children who were outside the locked door heard thuds, heavy thuds. I think that one of them said they heard some sort of gasp, and they heard their father say, "Be quiet," and the father said to the boy, "Nathaniel, it is me," all while this was going on. So I would suggest that the evidence shows that there was nothing instantaneous or sudden about any of this. Certainly not the beating with the victim, and certainly not the defendant's decision after a month to return to the home. There was evidence in the morning immediately before the killing, that was on June 8th, and in the evening or day of June 7th, he texted with a niece saying his goodbyes. "Tell my mother I love her. If anything should happen to me. Oh, and by the way, make sure my mother gets my cell phone." And on that cell phone was a calendar entry for June 8th, the day that the defendant killed the victim, saying just Judgment Day. And then the following day, there was, that evening there were text messages with a mutual friend, and he was asking the mutual friend, "What is the victim saying about me? What's the gossip going on? She claims to be a Christian. Laugh out loud. Let's see if God saves her from this one." And the woman, the friend says, "What are you planning to do?" He says, "You know me." And it was the next day where the defendant goes to the home and kills his wife, strangles his wife. And either before obviously before he goes to the police station and confesses to the killing, he goes to his mother's apartment and provides the cell phone with the Judgment Day entry to his mother's husband with instructions to give it to his mother. And when he goes to the police station, when he's asked about the cell phone, he says the cell phone's disconnected and he doesn't know where it is. So I would suggest that the defendant's behavior, both immediately before the killing, during the killing, and after the killing, when he tells the children to go brush your teeth, I'm going to take you to school, and then comes home and tries to kill him, or comes back to the house, tries to kill himself, doesn't bother looking in on his wife to see if she's alive, conscious, it does not reflect the state of mind that you would expect for someone who is acting under the heat of passion, such that his homicidal rage could be justified as frailty of human nature. And I would suggest if that were the standard, then pretty much in any domestic violence case like this, that you would be a defendant would be justified in saying that, well, I made a mistake, and this is not a mistake.
Now, were any of the ligatures checked for her blood?
There was no evidence that, yes, all the ligatures that were found there was no evidence that any of it contained any blood. We could not point to one of them. There was that black cell phone cord on the bed next to the victim, but there was no evidence of any forensic significance that was introduced at trial.
Did the Commonwealth argue that one of these, a particular item was the ligature?
I believe the argument was that any one of them could have been the ligature, and whether they were wiped clean or whatever, I don't know. I don't know that he made that argument, but we did not have the evidence to identify any one of the, but there was, and a photograph of a knife that was found on the bureau in the bed was entered into evidence, and the judge entered it into evidence because the jury could have inferred that it could have been used to cut, and there was evidence of a white, I believe it was another phone charger, found on the daughter's bed down the hallway, that the ends had been cut. But there was no forensic evidence identifying the actual murder weapon. But there were ample cords and rope throughout the house that could have possibly been used, or it wasn't. It was no longer in the home. But the fact of the matter remains that the jury was well warranted in finding that the defendant deliberately premeditated this intentional killing. And his testimony, such as it was, and it really sort of stops. He says, oh, she was swinging at me, she was lunging at me, and that was the last I heard from her. But then when pressed for any details about their interaction, he doesn't remember. I don't remember. He doesn't remember removing the ligature. He doesn't remember locking the door. So I would suggest the term snap as used, and I found a dictionary definition in my brief, is more of like some sort of a mental breakdown. But that really was not argued. There was no evidence. There was no evidence to support that, and I think there was a discussion about jury instructions along those lines, and the defense admitted that she has no more evidence than was already presented. But that, again, doesn't entitle you to, that may, if you have evidence of it, that may go towards an acquittal because you don't have the intent to commit the crime, but that's not the type of evidence that we had here. And I would suggest just his simple assertions that I snapped, I blacked out, without context, without a description of what that meant, what you did. I would suggest that doesn't really get the defendant anywhere. Certainly that shouldn't provide a basis for a voluntary manslaughter instruction.
If he had said, again, I don't know, I guess there's some dispute as to precisely what the strength is of the evidence that she hit him, but if she were to say, she hit me, one does not need to add, I lost it, I snapped, in order to necessarily trigger the voluntary manslaughter instruction.
Well, I think you need to say what the hit was and what the circumstances were of the hit. It has to create some risk of harm. But the whole point is that you're justifying your reaction, and if your reaction is to immediately take a deadly weapon and place it around somebody's neck and hold it for 3 to 5 minutes, I would think that the provocation in law for a reasonable person should be more than a shove, more than a punch.
Was there anything about the relative sizes of the parties? I can't get any sense of what they...
No, I don't believe that there was. I'm not sure. I can't answer that definitively, and I've certainly
From
looked.
somebody who's 6'4" and you're 3'2" could be a different story than the reverse.
Well, I think the physical evidence of the victim's body shows that she certainly got worse than she ever...
Do you know what her size was from the autopsy?
I don't know if that's actually in the record, Your Honor. I don't believe that came into the medical...
testify to...
I don't believe the medical examiner testified to...
And the
But I don't- I
autopsy
can check
report
that.
wasn't admitted or put in as an exhibit or as a, for identification or anything.
I apologize, Your Honor, I do not know that.
But we
I
can
will
check, we can check the beginning of the ME's testimony to see whether or not he gave height and weight.
Right, yeah, and I will do that too, Your Honor.
Anything about the defendant?
Excuse me?
Anything about the defendant? How big a guy? I mean, we know he was a bodybuilder, but other than that, I mean...
No, I know that his statements to the police on the day of the murder were video recorded, I believe.
In other words.
I believe there's a CD, yes, where you could actually see, and there were photographs of, I believe, of the victim entered into evidence. Obviously pictures of I don't know if they're autopsy photographs, but there were photographs of the victim entered. But there also was testimony that the defendant did spend, that's how he dealt with the marital discord. He went to the gym 4 days a week. But whatever it is, I mean, the fact of the matter is this was not any kind of hand-to-hand combat. He did take some sort of ligature from somewhere, whether he brought it with him, whether he picked it up at the time, and placed it around her neck for the 3 to 5 minutes that it took to kill her. And I would suggest, in those circumstances, any defendant would be hard-pressed to justify that his actions were simply voluntary manslaughter and not intentional, premeditated murder. So I would ask the court to affirm the verdict. The evidence is overwhelming. There's no basis in the facts to warrant a reduction of the verdict or a new trial. So I would ask the court to affirm the defendant's convictions.
All right, thank you.
Thank you.
And we'll take our morning break.
Court, all rise.